So let's talk a little bit about our third issue. It's types of arbitral tribunal. In Ukraine it's a great situation, and in the world too, that arbitral tribunals can be in two types. It's arbitral tribunal ad hoc and permanent arbitral tribunal. Arbitral tribunal ad hoc is those that are formed to hear a specific case. The arbitrators may be just not professionals, and based on the analysis of legislation, we can observe that in Ukraine we can abuse the opportunity to transfer the case to arbitral tribunal. Firstly, the ad hoc tribunals are not registered in the Ministry of Justice of Ukraine. They just are not legal, but the law provides them to work with us and to resolve our disputes, and it's a great legislation gap. Arbitration clause or agreement can contain the will of the parties to arbitrate this dispute in arbitral tribunal ad hoc or permanent arbitral tribunal. So we can conclude that operations of ad hoc tribunals need to be more regulated in the legislation. First of all, I think that in legislation we should provide the provision that arbitrators ad hoc should be professionals, and to provide the list of necessary skills for them, as we have to the arbitrators who work in permanent tribunals. Instead, the procedure for the formation and operation of permanent arbitration tribunals is provided by the law. And if we have the situation that all the decisions rendered by arbitral tribunals, both ad hoc and permanent, are valid, are final and irrevocable, so we need to regulate the sphere of arbitration and to make arbitration more regulated, because the party who wants to abuse another one, who wants to cheat somewhere, can use this gap. I think it's too easy for you, and it's just short information about this. You can read this in the act, in the books. It's very useful information for your future career. The next our issue is arbitration clause and arbitration agreement. To transfer the dispute to arbitral resolution, it doesn't it is not different to arbitral ad hoc or permanent arbitrators. Parties should include into contract arbitration clause or arbitration agreement. The ICC, what is International Chamber of Commerce, provides out the typical arbitration clause which you should include. This arbitration clause sounds as all disputes arising out or in connection with the present contract shall be finally settled under the rules, and you should write which rules you will use. In this case, we have of arbitration of the International Chamber of Commerce, and then we write by which court. It may be just name of the arbitrator and his address and just connections, or a name of the court, permanent or ad hoc. If you did not include to the contract such arbitration clause, you can enter into arbitration agreement. It will be separate agreement, and it will be like appendix to your contract when you state the same information. So the Article 18 of the law on arbitral tribunals indicates the list of people who cannot be arbitrators. This list includes minors, people under guardianship, people without specific professional skills, people who have been convicted, people found incapable by a court, judges of court of general jurisdiction, or the Constitutional Court of Ukraine. And here we see the gap, because this list includes people without professional skills, but as I mentioned before, the arbitrators ad hoc can be non-professionals, and it's forbidden and it's allowed by the law. So, do you understand this?
Yeah.
Okay,